Hi guys, this is Leslie of Sultan Attorney, and I'm live today, the first time live for 2022, and I'm here to answer estate planning questions for you. A will, as I like to say, is your ticket into probate court. Both do the same thing. They both offer details for how you want your assets to be distributed after you pass away. When you pass away, if you want to just designate, okay, I want my money to go to my sister, I want my children to have the house, etc., that can be done in both a will and a trust. The difference is the will has to go through probate. That means that it has to be submitted to a judge. The judge has to verify that it's legit, that someone didn't go and write it up in their house and put fake signatures. And then the will becomes validated, and then you can use it to distribute the assets. So you can't take a will into a bank after somebody passes away and say, hi, my dad just died, here's his will, give me all the money. They won't do that. So that's what a will does. A trust, on the other hand, is basically a contract with yourself. It's basically you're saying, I'm going to transfer all of my assets into a trust that I control while I'm alive. And then when I pass away, the next person that I name will take control of my assets. So for example, your house. Right now, if your name is on the deed, you have to transfer that so that the name on the deed goes to the trust. So Leslie Sultan would transfer her house to the Leslie Sultan Trust, or whatever you'd call it. That puts it into the trust. The analogy I like to use is a purse. That's how, like my podcast, the legacy purse. Everything that's in the purse is controlled by the trust. So the trust is the purse. While I'm alive, I'm controlling all of my assets. I'm taking my wallet out of my purse. I'm spending money. I'm putting it back. If I can put my house in the purse. When I sell the house, I get a check. The check goes to the trust. It goes in the purse. And while I'm alive, I have all that control. Now, if I drop dead tomorrow, the next person that I name, so it might be my kids if they're over 18, or a friend, they're going to be able to take that purse off of me and put it on their shoulder and control it. What's missing here? The court process. There's no court involved, no judge. It's all private. It's kept out of the courts. The main key is that it avoids probate. So everything's done right away. Okay, so I explained to you what a will is. When I say a will, I'm referring to a last will and testament. It's my last wishes and my testament of how I want my assets to be distributed. So last will and testament is the document that's going to go through the court system and be probated so your assets can be distributed. A living will is actually a healthcare document. It's a document that we use to help have our clients designate how they want to be treated in the event that they become incapacitated and can't make medical decisions for themselves. So it might say, you know, if I'm on life support, I want every medical remedy in ever, you know, to keep me alive as long as possible. Or it might be, if I'm brain dead and there's no hope for me, you know, right now with modern technology, just pull the plug. You know, these are decisions that are very individual, very personal, but if your family or friends don't know what those are, it's very hard for them to make those decisions for you. So a living will dictates exactly what you want. So why they couldn't have called it something else, I don't know. It creates a lot of confusion. But hopefully for my viewers, you understand the difference now between a living will and a last will and testament. We usually pair a living will with something called a healthcare proxy. And that's a proxy, that's a document to nominate someone as your healthcare agent. And then that person can help make your medical decisions. So that's a great question. The whole purpose of probate is literally to make sure that creditors get paid first before the family gets their assets. So what happens with probate is you file the petition and it's a public record. So a lot of creditors like credit cards, banks, Medicaid, all these people that you know, have big stakes in the game, want to make sure they get their money, they search those. They have systems to search the probate records. And the minute somebody pops up as dead and a probate is opened, they get notified and they show up in court. So when they show up to court, the first thing they do is submit their bills, and they say we have to get paid, and the judge is going to make sure that those bills get paid first. It is possible to negotiate sometimes, but this again is why you want to do trust planning, because there's no probate, there's no notice to the creditors. In some instances you might need to notify a creditor because you're going to change, the mortgage, for example, would be changed to a new signer or something like that. But generally speaking, you can avoid some creditors, and creditors have a 7-month statute of limitations. So if they don't step up within 7 months of the probate, they waive their right to collect it through the probate court. But generally, depending on the debt, it does, the estate is responsible for it. So your question is, my dad has debt, will I be responsible for it? The debt doesn't pass on to the heirs, but the estate would have to pay the debt before it can distribute amongst the distributees or the family members. The court in New York has a range. So if it's based on how much is in the estate. So anything, I think it's from $250 to $500, costs $625. That's the court fee. And then you have to get the attorneys. So like I said, as an attorney, when I had a probate case, I take anywhere from $5,000 to $10,000 retainer, charge an hourly rate of $450. So it goes quickly. Usually the $10,000 covers everything. But if there's a contest, if somebody's contesting the will, or if there's a family member who's creating issues, if there's creditors that have to be negotiated with, that's going to obviously eat up the retainer a lot faster. Yeah, you want to avoid probate as much as possible, and definitely trust planning is the way to go. For anyone listening who is a parent of minor children, one of the greatest things we do with estate planning is naming minor children. So minor children cannot inherit money, and they cannot obviously live on their own. A guardian has to be appointed for them. So if you, as the parent, don't name someone, then you're opening up that process to anybody. I have a brother who hasn't talked to me in 20 years, unfortunately, but he might decide, oh, I'll come and take care of my kids. Like, I would not want that. I haven't spoken to him. He doesn't know my values. I was a child the last time I knew him. Now we're adults. I mean, it's just a whole nother thing. It's very common when you have parents, the grandparents, right? They might fight over which set of grandparents would raise those children. But the parents have the option to nominate someone, and that gets considered by the judge, and that's a big plus. I had a client, she had a child with someone, and that guy was never around, basically abandoned the child. So if she were to pass away and he tries to step up, she did not want him. We did an exclusion, a guardian exclusion letter to prevent him from coming in and trying to raise the child. So anyways, naming long-term guardians, that's part of the estate plan. It goes into the will. And we also do a temporary guardian. So for example, if I wanted to name somebody and they lived out of state as the long-term guardian, and something happened to me, the police or somebody would come to the house, they'd get the kids, and they'd say, okay, where's the long-term guardian? I said, oh, she's in Florida. And they'd say, how is she going to get here? We can't leave the kids overnight. They would take the children into protective custody, and depending on how long it would take my guardian to come, they would wind up in the foster care system, because the police have a responsibility to make sure the kids are safe. So they're going to put them, call Child Protective Services and have them placed until the guardian can come. So that is absolutely not what I would want. So instead I could name temporary guardians, people that you might not have like a ability to raise them long term, but could hold them overnight for a couple days and feed them and get them to school. So that's a big thing that we encourage, doing temporary guardians and long-term guardians for estate planning. Thank you so much for joining. I appreciate you guys, and I look forward to answering more questions in the future. Okay, thank you.